Right, while people are still coming in, I will just kick off with a few kind of housekeeping matters. There is a Q&A function at the bottom of the screen where you can ask questions. Please probably wait until the end of our speakers' discussion so that you might find that some of your questions are answered through the course of the webinar. These questions won't be seen by other audience members. It will only be the panel that see them. So don't be worried about asking anything that might reveal your name. You can keep yourself anonymous. I'd like to welcome you to this webinar today, which is our first webinar of the series, or of our new academic or research forum, which is a very exciting forum where it is a way for people who are interested in research, whether that's students, academics, those working with migrants in other forms, to connect, share knowledge and learn from each other. Membership is open to students, academics and practitioners engaged in migration-related research. And as part of the forum, we will be having roundtable discussions like this one, webinars and opportunities to connect with other members and also publish work on our website. And you can check out the website for more information, and I'll put more details in the chat function in due course. I'm going to hand over to Gillian, who is the Vice Chair of the network, and she is head of the research forum, and she will be introducing our fantastic speaker today. Over to you, Gillian.
Thanks, Imogen, and thanks everyone for coming along. And to those who are catching up on the recording, thanks as well for tuning in. We're delighted to kick off this academic year's research forum with Dr Bríd Ní Ghráinne, who is an assistant professor at Maynooth University, and she has extensive research expertise on internally displaced persons, and that's really going to be the subject of the webinar today. Bríd has recently published a monograph, a book, with Oxford University Press, and I believe that the theme of the book is also going to be the theme of her talk tonight. So I'll not take up any more time. I'll let Bríd take the floor and introduce her research and her book. And then as we go along, if you'd like to add any questions, there's a Q&A function, as Imogen has said. And yeah, without further ado, I will hand the floor over to Bríd. Thank you.
Thank you, Gillian, and thanks to Imogen as well for introducing me and for hosting me here today, and to Scott for all of the technical assistance. So my name is Bríd, as Gillian said. I work at Maynooth University, and this is my first book, hopefully the first of, well, more than one, I don't want to say many, on forced migration. So I'm delighted that you're here today. Thanks so much for joining me, and thanks very much for catching up for those of you who are joining us later. So the purpose of my presentation today is just to raise awareness of this book, and really to hopefully make connections with those of you who might have shared research interests with me. So we'll have a chance to discuss it in the Q&A, but I hope that's not the end of the discussions. I'll put my contact details up at the end. So please, if you'd like to continue the conversation another time, please don't hesitate to get in touch. Or if you think we might have some shared research interests, or, I would be really happy to hear from you. So just as a bit of background, I've been researching internal displacement for over a decade, and this book stemmed from my doctoral research, which was initially supposed to be about the protection of internally displaced persons in international refugee law, in international law. But I had Guy Goodwin Gill as my supervisor, so it naturally, refugee law really naturally influenced my project. And what I thought was one chapter of the thesis, the relationship between internal displacement and international refugee law, well, it turned into a bit of a rabbit hole, and it turned into the thesis as a whole, which is often the way with doctoral research. So yeah, since then, I've just been tapping away at this book, trying to get a contract, and got it published last year. So I'm really happy that it's finally out, and yeah, very happy to talk to you about it today. So moving forward, so most of you already know, the essentially what it is an IDP and what it is to be a refugee. So essentially this book looks at the relationship between these two categories of forced migrants, and an IDP, internally displaced person, as many of you know, are persons who are forced or obliged to flee or to leave their homes or places of habitual residence for a variety of reasons, such as war or conflict or human rights violations, natural disasters, for example, but who haven't crossed an international frontier. So there's 59.1 million IDPs in the world today. And what really struck me about the term IDPs is that I only ever came across this term in the third year of my undergraduate studies. I'd never heard of it in the media. I'd never known the concept before, but compared to refugees, like even my 12-year-old niece talks about refugees, like it's something that we learn about from when we're very, very young. And that's part of the issue that I deal with in my book, this, the difference of international attention that's placed on these two categories. So refugees, as you're aware, I'm sure, are people who are outside their country of nationality or habitual residence, because they have a well-founded fear of persecution and they're unable or unwilling to get protection from that state. And that definition is much more narrow than the description we have for IDPs. There needs to be persecution for one of the listed reasons in the convention: race, religion, nationality, membership of a particular social group, or political opinion. And there are 27.1 million refugees in the world today, roughly. I just should say that these figures are very likely an underestimate for all sorts of reasons, but it does serve as a very rough yardstick to show us that there are many more IDPs than there are refugees, around 2 to 1, very, very roughly speaking. And my research is based on the premise that IDPs and refugees are similar in so many ways. So even though we treat them differently in law, they often flee for similar reasons, such as human rights violations, armed conflict, things like that. They often have similar needs, such as need for shelter, education, basic necessities. They often live side by side, even. Many IDPs cross the border and live, many IDPs become refugees when they cross the border, and then they live side by side with refugees. Most of the world's IDPs and refugees are located in developing countries. Displacement, whether you're an IDP or a refugee, can last for years or even decades or even a lifetime. And both IDPs and refugees face significant uncertainties about the future. They're both far away from their homes, in new environments. They might have lost or been separated from family members along the way. They mightn't have access to the same services or assistance they had in their home place. They might feel tension in their new environment or discrimination. And it's really important, like the fact that they just don't know how long this is going to last for. So how on earth do you plan what you're going to do this year if you don't know if you're going to stay where you are or go back where you came from? So like the fact, do I learn the local language or not? Do I try and get a job or not? Should I enroll in the school or not? There's so many uncertainties. And often both IDPs and refugees have significant mental health problems, for example, for a variety of reasons, but also because of the fact that the future is just so uncertain. But there's one crucial difference between IDPs and refugees made by lawyers, which is the fact that IDPs remain within their country and that refugees have crossed the border. And that's really important in terms of the type of protection that both categories of migrants get. So crossing the border puts refugees in a relatively privileged position when compared to IDPs in a legal sense, because they have a legal status. They're protected by the 1951 Refugee Convention. There is a specific international organization for their protection, the UN High Commissioner for Refugees. The IDP, on the other hand, remains within their country, and traditionally IDPs have been seen as a domestic issue. We don't have an international IDP treaty or convention like we do for refugees, although there are some regional conventions in Africa. So it's essentially seen really as a domestic matter. And even though IDPs have, as human beings, are entitled to protection from international human rights law, international humanitarian law, and they're entitled to protection from domestic law as well, we don't really have like international IDP law in the same sense that we do for refugees. So put simply, even though IDPs and refugees are similar for many, many reasons, there's very good reasons why they have separate legal frameworks. IDP protection is a lot more controversial than refugee protection because they're within their country. So any international protection for IDPs could be seen as an infringement on state sovereignty. And the world pays less heed to IDPs. They're less visible than refugees for many reasons, but probably the most significant one is the fact that refugees cost money to Western states, and IDPs remain within their own countries and really are the financial responsibility for taking care of IDPs lies with their own governments. So as such, the world's attention has really focused on refugees to the detriment of IDPs, I would say, even though IDPs outnumber refugees by almost 2 to 1. So moving on to the book that I wrote. Refugee law has been the study of countless books. There are full sections of libraries devoted to international refugee law. There are centers for the study of international refugee law. There are many international refugee lawyers in the world. But IDPs have received comparatively less attention in the literature. And that's not to say that there isn't work on IDPs, but certainly a lot less compared to refugees. And actually even more often, so even when IDPs are studied, they tend to be studied in isolation without looking at the relationship between internal displacement and international refugee law. So that's why I wrote this book. It was the first book-length study on the relationship between IDPs and international refugee law. And actually, another point I forgot to mention on the similarity between them is that IDPs often cross the border and become refugees, and often refugees might go back to their own countries and become IDPs as well. So, this idea of being an IDP and refugee, it's not an either or. Many people are IDPs at one point of their lives, and then they might be a refugee, and then they might be an IDP again later. So it really is it's a transient, not even status, because IDP isn't a status, but it's a transient sort of categorization of a person. The moment you step across the border, suddenly how we think about you in international forced migration law might be quite different. So what does the book do? So even though I said that international refugee law or international IDP protection has been significantly less studied when it comes to international refugee law, and I said that we don't really have an international IDP law framework like we do for refugees, that's not to say that there's nothing on the protection of IDPs. There's been a couple of very important developments over the last few decades. From the 1970s onwards, the UN and the General Assembly started talking more about people displaced within their countries. And we can think, for example, of the era of preventative protection and humanitarian intervention in the 1990s and early 2000s. So traditionally, human rights was seen as a domestic issue, but in the last few decades, we're seeing more and more, not acceptance, but at least discussion or raising of the idea that violating a state can't just violate human rights and say it's not the international community's business anymore. With sovereignty comes responsibility, and there may be circumstances in which the international community has an obligation or a duty or a right or an interest in intervening. It's very controversial, but at the very least, there seems to be general acceptance that human rights issues are no longer just a domestic affair, and that the international community does have a role in promoting the protection of human rights, even within countries. And there's actually been some examples since the 1990s of states intervening with force in other territories, ostensibly for the protection of human rights, but there's always other interests at play. I would say usually the other interests are the driving interests, but at least that's the official line. And the creation of safe zones in particular for IDPs. There are examples in Iraq and Afghanistan, more recently in Syria in 2019. And there's also been the development of a distinct legal framework for IDPs. The most important instrument in this regard is the Guiding Principles on Internal Displacement, which is technically a soft law instrument. So it's technically non-binding, but if you take a closer look, there's at these 30 principles. Many of these 30 principles are actually based on various principles in international human rights conventions and in international humanitarian law. So there's a prohibition of internal displacement, for example. And even though we don't have that prohibition in a human rights treaty per se, the right of freedom of movement, for example, supports that. Maybe the right of protection of home and family life. So really you can piece together, you can draw a lot of these principles from existing hard law obligations. And there's also been 2 regional treaties on IDP protection in Africa that are very much inspired by the Guiding Principles. And I should also say the Guiding Principles have been very warmly welcomed by the General Assembly, for example, the Security Council. They're cited very, very often and have been described by the General Assembly as the key international framework on IDP protection. And perhaps even more importantly, many states, I think around 45 at last count, have used the Guiding Principles either as inspiration for domestic laws and policies or have drawn from them directly. So they've really had an impact for a document that was not drafted by states, that was drafted at a time where states were a bit suspicious to intervention on behalf of IDPs. And yeah, they've been quite successful, I think. And also there's the development of an IDP institutional framework in the 1990s. So the UNHCR began to become more involved with IDPs. The international community set up the cluster approach of humanitarian protection. So the division of responsibility for IDPs became more clear. And even though all of these activities are generally speaking a positive development, right, because it draws attention to the plight of IDPs, there was a concern at the time that these activities might be seen or invoked as an alternative to asylum. So this idea that a state that receives a lot of refugees might say, to an asylum seeker, you're not a refugee because you can go back home and, seek protection as an IDP. Or we don't have to accept refugees because we've put a lot of money into this program that's happening in the country. And therefore, we've done our bit for the international community when it comes to protecting forced migrants. So yeah, this concern was brought up by academics, but also by UNHCR itself. And that was the focus of my thesis and book, really. Is the increased protection of IDPs complementary to or in conflict with international refugee law? So basically, I think this monograph is important because it challenges the practice of using IDP protection as an alternative to asylum. So moving on, and more reasons why I thought it was important. A detailed analysis of the relationship between IDPs and refugees is long overdue. We're now witnessing the highest numbers of people displaced on record, and that's led to significant state hostility towards refugees. And you can see this, in practical terms, with states implementing pushback measures, tear gas at the borders, deporting a lot of asylum seekers, implementing travel bans, building walls. There's many examples from many different countries. And also in a legal sense, states are being a lot more restrictive about who they recognize as refugees, narrowing their interpretation of what it means to be a refugee. One example is the internal protection alternative concept. So it's this idea that an individual is not a refugee. Let's say, for example, you come from a village in Somalia and the Irish government accepts that your life is in danger there, that you have a well-founded fear of persecution for a convention reason. But they might say that you could go to Mogadishu, the capital city, and live there relatively anonymously, and that your persecutors can't find you. So this idea that, you know, we accept that your life is in danger where you are or where you come from, but you can relocate within your country and seek protection somewhere else within your country. So we're not obliged to protect you here, because really it's up to your home country, and only when that's exhausted, only when that option is exhausted, does the need for international protection arise. So in applying this IPA concept, states have already explicitly cited IDP protection measures, such as the availability of safe zones as a basis for refusing asylum seekers. So yeah, that's an example there from the Turkish policy of creating a safe zone in Syria. And you know, this idea of a safe zone isn't anything new. It was something that at the time was put on the table by a lot of different states. It was a big part of Donald Trump's, I guess, his promises when he never followed through with it, thank goodness. But he very much was pushing this idea of a safe zone, and so was Iran and Russia, before Syria eventually followed through with this plan. So moving on to the questions that the book looks at. First, I look at what is the legal and normative relationship between IDPs and refugees. And I've already discussed a little bit about that already. Essentially, it traces, you know, why are they similar? Why are they different? Why do we have different legal frameworks for them? And is this justified? And essentially, I argue they should be treated differently in law, but we need to focus on how these two branches of law conflict and complement each other. So I also look at to what extent is an individual's risk of internal displacement in their country of origin, or country of, nationality or habitual residence, relevant to the qualification and cessation of refugee status. So could somebody argue, for example, I'm a refugee because in my home country I'll be an IDP, and that makes me a member of a particular social group? Could that be used as part of a asylum application? So to what extent is forced displacement an example of persecution in terms of qualifying as a refugee? And then on the flip side, to what extent could somebody, would it be legal for a state to send somebody back to a country when refugee status is ended, even if they'll become an IDP? So refugee status doesn't last forever. States may have the right to, refugee status might cease for a variety of reasons, but mainly when the reasons for which the recognition took place in the first place no longer exist. So, you know, perhaps the war is over, or perhaps the persecutory government is no longer there. But if you go back to your own country, you'll be an IDP. Is that okay? Can refugee status cease even when someone will be another form of forced migrant, but within their country? And also, to what extent is the availability of IDP protection measures an alternative to asylum? So this focuses a lot on this idea of the internal protection alternative. You know, can a refugee receiving state like Ireland say, you're not a refugee because you can go to the UNHCR camp within your country and receive protection there as an IDP? So we don't know to what extent being an IDP or those sort of measures, or being an IDP supports or is evidence in favor of, or evidence against somebody being recognized as an IDP. And I look at a lot of case law, mainly from, well, not that much, well, the ones I found were Canada and Australia, specifically, on whether it's okay under refugee law to send somebody back to a country where they'll end up being an IDP. So essentially to condemn somebody to another status of forced migrant. And it seems that it is. The whole concept of internal protection alternative is based on the idea that you're going to live in a different place from where you used to live. So, you know, arguably applying this idea of internal protection alternative means that somebody is an IDP. And the jurisprudence that I found essentially, you know, it was acceptable to send somebody back, even if they lived in an IDP camp, even if they ended up living in critical shelter arrangement, such as a tent or temporary accommodation like a mosque. So essentially, courts support the idea that you can reject a refugee application, even if it means that that person will become an IDP when they go back to their country. I also look at the idea of whether protection by non-state actors, such as UNHCR, could be viewed as an alternative to refugee status. So the Refugee Convention talks about protection of that country, and you're a refugee when inter alia, you don't have protection of your own country. So what happens if, you know, a receiving state accepts that you don't have protection of your country, but they say, but you can get protection from an international organization. Can the international organization, you know, replace the state as a provider of protection? Short answer, I said no. And there's more details in the book. So the key argument of the book then is, I argue that the IDP protection framework, at least in a legal sense, doesn't undermine refugee law. And that's because an individual is not a refugee where there's protection or persecution from their state of nationality or habitual residence. So you're not a refugee if there's protection available in your home country from your own state. And that standard of protection is really, really high. So there needs to be effective protection from persecution and no risk of refoulement. So no risk that you'll be sent to a place where your lives or freedoms are in danger. So in order for IDP protection measures to be an alternative to asylum, they'd have to satisfy this really, really high standard. So the standard they'd have to satisfy is that effective protection from persecution and no risk of refoulement. And as you can imagine, that tends to not be that doesn't tend to be the type of protection that is provided to IDPs. I mean, in order to do that, you'd need to have like a functioning police force, for example. You need to be able to like forcibly, physically protect people from violence, and to be able to have the conditions in which they live of such a standard that they wouldn't feel the need to go anywhere else, that they wouldn't need, like that there wouldn't be danger of constructive refoulement as well. So the standard there is really, really high. So, but if the protection available to IDPs actually met this high standard, if there was effective protection from persecution and no risk of refoulement, then I think it would be appropriate to say, okay, then they're not refugees because the root causes of displacement are being addressed. And therefore is a sort of antidote to the protection persecution fears. So essentially what I'm saying is, to put it in a more simple way, is that in order for IDP protection in the home state to be an alternative to asylum, the standard has to be really high. There needs to be effective protection from persecution and no risk of refoulement. I can't think of examples where this is happening, but if there was such a situation, that would be okay, because essentially it means that the person is safe at the end of the day. So an assessment should always be done on an individual basis. So that, you know, there is a risk, of course, that states will say point blank, you know, there is protection available to IDPs in that country, so therefore we're not accepting, we see that country as a safe third country, for example. But you need to take into account an individual's needs, their reasons that they're fleeing their home area. Perhaps, you know, perhaps it's safe for a male to go back, but it mightn't be safe, but it mightn't be safe for, you know, a single woman to go back, for example. So everyone's particular circumstances have to be taken into account. Okay, so moving on. So I'll leave it there, and very much welcome any questions or comments. And you can find my details there on the, well, maybe soon to be defunct Twitter, but my email address is there, which will stay available. So I look forward to discussing this with you, and thanks so much for coming.
Thank you so much, Bríd. Such an interesting presentation, and I think a really underexplored area, and lots of questions going on in my mind. But just to our participants, if you do, we have a few questions that have already come in, but just if you do want to pose a question, you can do that in the Q&A. So I'll just maybe kick off with a couple of questions, Bríd. So there's one from Kayla Yoon, who is asking whether the standard of protection from persecution that the IDP is seeking is more expansive than persecution. which is based on the 5 grounds, as you know: nationality, race, religion, etc. So I guess whether that's standard of protection from persecution, and I suppose I would just add in there, you know, beyond persecution, in terms of the IDP context. So Bríd, I don't know if you want to take that question first, and then maybe we'll move on to another one.
Sure, thanks, Gillian, and thanks so much, Kayla, for that question. That's something I deal with in more detail in the book, but I didn't go into it in the presentation because you could be talking about it all day. But essentially, in the book, I go into the question of could somebody argue that their internal displacement is a form of persecution and in their own country, and that could be a grounds. You know, there are lots of criteria for refugee status, but that's a really crucial ground that you need to show that the fear that you have in your own country qualifies as persecution based on a list of the grounds that you mentioned. So I looked at it from 2 different angles. Like, first of all, okay, I'll try to word this in the clearest. When it's on paper, it's much easier. So first of all, we need to define whether or not internal displacement is a form of persecution. So, you know, persecution is it's generally accepted as sustained or systematic human rights violations, and we don't have a prohibition point blank of internal displacement in international law. But I think that there's enough there that you could argue that it is against international human rights law. There's, you know, plenty of prohibitions plenty of protections for freedom of movement. You could draw from the prohibition of cruel, inhumane, degrading treatment, protection of family life, protection of the home. So I think it would be that part of a claim would be, I think, pretty not easy, but you know, not an insurmountable hurdle. The part of the claim that I think would be harder would be the fact of linking it to one of the listed grounds. So it is very much conceivable that someone could show that perhaps their ethnic group is being targeted, and that they're being forced to or obliged to leave their homes, and to link that to the sort of concept of persecution as a violation of human rights that I just said. But then in that case, it wouldn't be the fact that you're an IDP necessarily that you would be making your claim, but rather that you're a member of that particular group. That would be your discriminatory ground. And then the human rights violation, you'll be pulling from other, you know, the various rights in international law. So essentially, I don't think the IDP concept wouldn't be really necessary to use there. The question of whether being an IDP itself, that's the first part. But the second argument maybe that could be made is whether being an IDP in itself could make you a member of a particular social group. And that question actually came up with some case law before Canadian courts, I think. I don't have the name of the case. Actually, I think a lot of those cases had numbers actually as their name, so I wouldn't be able to remember it anyways. But essentially that was rejected on the grounds that the argument they were making was because of the conditions that they were exposed to, rather than them being part of a particular category of individuals. And I can't remember the whole reasoning, but essentially they said that it wasn't a particular social group. So yeah, I think from whatever angle you take it from, it would be very difficult to show that internal displacement in itself would bring you within those grounds. But you could certainly, you know, argue the human rights angle of you know, maybe having been displaced from your home. Yeah. So yeah, that's that answer to that question, Gillian.
Brilliant, thanks so much. There's a couple more that have come in. I'll just ask them together. So one, I'm not sure who it's from. I don't have your name, but I think it's in relation to your sort of argument about the protection standard that would need to be met, you know, that you talked about in your last slide. And it says, is there any other definition to the protection standard apart from effective protection from persecution and no risk of refoulement? And then we have another anonymous question, which is, how do you explain this unwillingness to protect migrants at a national level? So I guess, yeah, I'll hand over to you for those, Bríd.
Yes, thanks so much for the question on the protection standard. So I should have mentioned there are lots of different interpretations of this, and the threshold that I give on lack of persecution and no risk of refoulement is the baseline, basically. Some states, so it's very clear from reading the 1951 convention that this is the absolute bare minimum, because it's written into essentially it's written into the convention. So refoulement is guaranteed, prohibition of refoulement is guaranteed, and the fact if there can't be persecution. Persecution is an intrinsic element of the 1951 refugee definition. I'm not saying that standard is what should be applied. I think it's far too low, because you could essentially be sending someone to a situation where they're, where a very, very substandard or poor standard of living, or living in an IDP camp, for example, and that isn't necessarily the type of protection that we would want to see. Some states have more generous interpretations of that. There's a lot of discussion in academia about that. So James Hathaway, for example, has led the Michigan guidelines on the internal, I think they call it the internal flight/protection alternative, where they argued that actually the protection standard is much higher, and that actually the protection standard should mirror essentially the rights that somebody would have been entitled to as a refugee anyways. So this idea of all of those non-discriminatory rights in the 1951 convention, that they should be available internally before you can expect someone to return to an internal protection alternative. There's also some academics who say that the protection should be durable. I'm thinking of Jessica Schultz's book on the internal protection alternative, and there's a lot of merit to those arguments, but I try to focus on the book on what the baseline was, because I thought if I said it, whatever way I took, it's mainly an academic argument. You have a few states doing this, you have a few states doing that, you have a few academics arguing this, or a few arguments arguing that. So I use the baseline requirement as the absolute bare minimum. And there's plenty of caveats all around it in the book to say I don't necessarily agree with this, but this is what states are doing.
Brilliant. And there's another one there, and I'm not sure how you want to tackle this. It's quite a big question, but how would you explain this unwillingness to protect migrants at a national level? I wonder if that is, I'm not sure if that's to do with internally or maybe refugee receiving countries. I'm not sure, but Bríd, I don't know if you want to comment on that at all.
Sure. No, we see it in the most recent, the global compacts on migration. IDPs were just left out of it, even though they're the biggest category of forced migrants in the world. I don't think states care about IDPs the way that they care about refugees, because refugees turn up on their doorstep and are their responsibility and cost them money. And there's a lot more in the media about refugees. So maybe, the domestic public might have, at least we see, for example, with the Ukrainian refugees, there might be some more, and there are some examples as well in history that there might be more pressure on states to do more for refugees. And there's this idea, of course, from the states in which the IDPs live, that this is our territory, our problem, or there's no displacement here, that they're voluntary migrants, or states are often very, very hesitant to even call them IDPs, because if they are IDPs, then there can be more pressure on them internationally, if there is any pressure at all, to do something about it. So I think there are lots and lots of reasons why IDPs unfortunately haven't had the same level of attention as refugees.
Yeah, thanks so much. Really, really interesting. There's another question that's come in here actually from a practitioner, which is talking about the question and the discussion that which is probably quite central to your book, about whether IDP law and refugee law complement or conflict with each other. And this person has said, I've seen a lot with applicants from Iraq claiming refugee status in the UK, and the Home Office and courts saying that they can be returned to Iraq, but different parts of Iraq. So I guess this is also coming into the internal protection alternative. And the question here is, how would you recommend rebutting those arguments that they can live in other parts of Iraq? So a more specific question, probably relating to a lot of what you've discussed there. I don't know if you have any thoughts on that, Bríd.
Of course, it depends to where they're being sent, right? And what the conditions are like there. But I think an argument that maybe is I don't see it as much as I think it could be used, is the idea of constructive refoulement. So even if you're not sending someone to a place where their lives or freedoms are, immediately in danger, if the conditions there are so bad that they're forced to leave and end up potentially somewhere where their lives or freedoms are endangered, that would be contrary to the 1951 Refugee Convention. So let's say, you know, their persecutor isn't present there, but they'll end up in conditions where they're going to be homeless or living in you know, that they don't have access to food or medicines or healthcare or anything like that. That might push them to go back to where they came from, where at least they have family links. And that would be constructive refoulement. So I think that that's a way to, that would be my suggestion of like trying to anchor it more in the 1951 convention, so that it's not just about, because unfortunately when you just put it in terms of the human plight and the human needs, unfortunately the argument back is, well, you know, that's the same as everyone. And this idea that, you know, you can't simply be a refugee just because, you know, you'll end up in poverty, because that's not what the Refugee Convention was all about. But then you could say, yeah, but if that pushes you to a situation where your life and freedoms are in danger, well, then it's constructive refoulement and against the Refugee Convention. But that would be just a general thought on that. It would, of course, depend on the specific circumstances.
Yeah, thanks a million. There's another question in here about restorative justice. I don't know whether you want to tackle that. It's how can restorative justice contribute to those experiencing displacement and persecution? So I know it's slightly broader than the scope of the book, but if you do have any thoughts, feel free.
Gosh, I've never really gone into that much. This idea, the guiding principles on internally displacement, which is the key framework on IDPs, doesn't really address it that much either. They talk about durable solutions for IDPs. They talk about there's a right to reparations as well, but yeah, that right. The problem with that is it's not so well established in international law, so there hasn't been as much practice as we would like to see of states, you know, invoking those sort of provisions at the end of the displacement cycle. And one person who's working on this actually at the moment is Luke Moffat at Queen's University Belfast. So I would defer to Luke Moffat's work on this sort of question.
Brilliant. I see another question coming in here that it was definitely within the scope of your work, Bríd. I know this for sure. Yes. And it is defining who is and who is not an internally displaced person can be challenging. And so what's your position on whether the guiding principles are clear enough in explaining who is and who is not an IDP? So
Gillian is referring to a piece that I wrote for a journal that Gillian very kindly reviewed for me, and is still in that, you know, place of I've gotten told to make revisions to it and still don't know if they're happy with it or not. So that was exactly what this question was about. So I'm really, really glad that you asked. So whether the guiding principles are clear enough on who is and who isn't an IDP. And I would say it depends on the purpose for which you want to know who is an IDP. So the guiding principles were originally drafted as a non-binding guiding document. And the drafters were at pains to say that it wasn't meant as a definition, not like the sense of like the refugee definition, who says who is a refugee and clearly shows who, well, not clearly, but tries to be clear in showing who is and who is not a refugee, and where the beginning of refugeehood starts and ends. When it comes to internal displacement, it's so broad. Like it says the reasons for displacement are not exhaustive. It talks about forced or obliged to flee or leave your homes, which is very, you know, open. We don't even know what it means to be forced or obliged. There's no consensus on it in refugee or IDP studies, let alone, you know, in any discipline, as far as I'm aware. It's not clear when displacement ends. They also talk about durable solutions, or they refer implicitly to durable solutions, but it's not clear cut like it is for a refugee. Like a refugee, you know, the moment you cross the border, provided all these other criteria are met, like your refugeehood starts there. And then we have the cessation clauses where it's, you know, relatively clear, at least in a legal sense, when the refugeehood ends. So at the time the guiding principles were drafted in 1998, that was okay, because it was just at the beginning of the, you know, this development of the concept of who an IDP was. And it wasn't meant as any sort of legal status. But nowadays, this definition has essentially been copy-pasted into a lot of domestic laws as a legal status, or even if it's not legal status, it might be that it, technically, it mightn't technically be a legal status, but falling within this description gives rise to rights, or it doesn't if you don't fall within the description. And also, we need to collect data on IDPs, and we don't even know if you're just when displacement ends. Are children of IDPs? What happens if somebody has committed, certain very, very serious crimes, like in refugee studies, it's very clear you're not a refugee, but in IDP studies, it's not. So I would say, to take a long-winded way to answer that question, the way they were described in the guiding principles at the time was fine, because the purpose was just to give us some guidance. But nowadays, I don't think it's really suitable for the purpose with which the guiding principles are often applied, which is to clearly show who is and who is not an IDP, and to give people rights, or to tell them they're not entitled to rights based on that description. So states definitely do need to come up, I think, with more clearly defined circumstances. But there's a danger in that, right? Because once we start boxing things into definitions, it's just another way to tell people they're not entitled to rights. So, in the draft paper I have that I'm happy to share if anyone is interested, I try and tackle some of these questions.
Thanks so much. Yeah, lots of really interesting things to think about there. There's one more question, which is really to do with the unable or unwilling aspect of the refugee definition. So how does that sort of interact with the internal protection alternative, and particularly the unwilling aspect of it? I don't know if you've dealt with that in the book, or if that's something that you have any thoughts on.
So I think that it's really linked back to the well-founded fear aspect. So the Refugee Convention talks about having well-founded fear of persecution for specific reasons in a particular state, and is unable or unwilling to receive protection from that state. So, there might be, officially the protection might be available. There might be, a police force there available, or, a functioning court system. But in reality, if a single mother went to receive protection, that, they'd be in a lot more danger than if they hadn't done it at all. Or perhaps, there's, you'd be threatened by the gangs if you go and seek protection. So there's all sorts of reasons why the unwilling part is really important there. So I don't know, was there a second part to the question, how that relates to IDPhood?
Yeah, in the sense of, I guess, the internal protection alternative, like if it is there, but you're unable or unwilling, let's say, to avail of it.
I guess the same threshold would I would imagine a similar threshold would apply, because if you're talking about, maybe that there's protection available in one part of the country, if somebody can show because of their well-founded fear they're also unable or unwilling to go there, then their refugee status should be recognized. But it's also important to know that the burden is on the state, not on the once a prima facie case for refugeehood has been made out, it's up to the state to then show that there is an alternative within the country. So, and also that it would be within that person, that it would be fine for that person to seek protection there. So there should be a presumption where there is, the threshold should be very high if we accept that there's a well-founded fear in one part of the country. Generally speaking, it shouldn't be given that they should be able to find it in another, they should be able to find protection in another part of the country. But sadly, that's not what happens in practice.
Brilliant. Yeah, no, thank you so much. We are just coming up to the hour, so we'll maybe draw to a close there. But thank you everyone for your really great engagement. I think it speaks to the quality of the talk and how much we learned from it, just how much Q&A was coming through there, and just loads to think about on a really underexplored aspect of migration, particularly IDPs and the interactions with refugee law. So do follow Bríd's work. Obviously there's a link there. We can also send around the link if you want to purchase Bríd's book and engage with it a bit more, and dive into the arguments a bit more. You'd be very welcome to. Just one more question that had come in relation to the forum. was the how to join it. Imogen has posted some details in the chat. We can also email that through to participants afterwards. And this session has been recorded, so we can also circulate the recording if you want to listen again. But just really leaves me to say thank you to Bríd for coming along, for being so generous with your time at 5:30 on a Monday evening. We very much appreciate it. And thank you to all our participants as well for coming along. We will keep in touch with you about the next event, and I will close it there. So thank you, everybody. And particularly thanks to Bríd and Imogen. Imogen, I don't know if you want to say anything to close us out.
No, I was just going to say, well, a huge thank you to Bríd. I mean, that was really informative. And from my perspective as a barrister, I can confirm that IDPs do not get nearly enough attention. And when there is discussion about IDPs, it just isn't given, I suppose, the gravitas that really it needs to be. Thank you as well, as Gillian said, for all the engaging questions, really, really interesting questions that came in. So thank you all very much. And again, to echo Gillian, follow us, follow Bríd. You can find out more information about the research forum, and get in touch if you have any ideas for blog posts, webinars, and so on. So let's leave it there, and thank you very much for attending, everyone.
Thanks, everyone. Bye-bye.